Okay, so today we are going to talk about Federalist number 78 and Alexander Hamilton's response to Brutus's concerns that Brutus articulated when it came to the power of the courts. You'll remember that for Brutus, he sees the courts as probably the most powerful branch of the government, that they will be superior to the legislature, that their interpretation of the Constitution will be what is binding on members of Congress and the president. Not the Constitution itself, but whatever the courts say about the Constitution. And for Brutus, that's very frightening because the judges have life tenure, they can not be fired, they can be impeached if they commit a crime, but they can't be gotten rid of for bad decisions. In other words, the people have no way to hold judges responsible or accountable. And so Brutus is terrified of the federal courts. And he is especially afraid of this power of judicial review. And you need to remember, he roots the idea of judicial review in the word equity. He looks at the Constitution where it says judges will have the power to interpret the Constitution according to, in all cases of law and equity. And when he looks at that word equity, he says that will allow judges to go beyond the words of the Constitution and essentially read their own views into it, whatever they believe the reasoning spirit of the Constitution is. And so for all of these reasons, Brutus is terrified of the power of the courts and in particular this power of judicial review. Now, Hamilton could not let that slide. He couldn't let that go unanswered. And so he responds in Federalist 78 with his own explanation of judicial review and his own understanding of the power of the courts, which is fundamentally different from Brutus's. And so what we'll do today is look over Federalist 78. I'm not going to focus on everything I would normally if we were doing this in class, but I'm going to kind of hit the high points. And hopefully you've already read it and have a little bit of a sense of what Hamilton has to say. And then we will dig into a couple sections in particular to make sure we understand what his arguments are. So first thing, Hamilton is going to respond to Brutus in terms of just the overall power of the court. So Brutus thinks they're going to be superior to the legislative power, and Hamilton responds and says, actually, no, they're going to be the weakest branch. And so if you turn to page 228, you can see him making this argument. Right in the middle of the page, he says, whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, so in a government of separation of powers and checks and balances, he says, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. So pause there for a second. You'll recall Brutus says the power of the government will be brought home to the feelings of the people through the medium of the courts. In other words, people will feel the power of the government through the courts. And Hamilton, right at the beginning, says actually the courts will be the least dangerous and the least likely to annoy the political rights of the people. He goes on, the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of society, and can take no active resolution whatever. It may be truly said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. So, if you think about the powers of government, the executive branch controls the sword, and that could have a couple of different meanings. On the one hand, the president is commander-in-chief, so he controls the military. Another meaning of the sword would be that if you violate a law, you can be executed. You can have your head chopped off, and so the executive branch is the one who commands that power. The legislative branch controls the purse, so Congress decides how much money to appropriate and where it goes. And if you go on C-SPAN every year, you'll see a member of the Supreme Court come before the Congress, before a committee of the Congress, and ask for greater appropriations. The courts have to go to Congress and ask for more money to be able to do what they need to do. And so Hamilton's argument in response to Brutus is, you think the courts are going to be all powerful. They're going to feel like they're above heaven itself. They're going to feel like there's nothing that can check their decision-making authority. And Hamilton says, actually, they're the weakest branch because they don't control the sword and they don't control money. They have to rely on the other branches of government. And he makes this point at the end of this paragraph where he says, the courts can make a decision, but they can't actually enforce it. They have to go to the executive branch and hope that the executive branch enforces their decisions. And there have been famous cases in American history where presidents have refused to enforce judicial decisions. Andrew Jackson, very famously, is said to have quipped, although we don't know if he did this, where there was a decision of the court involving Cherokee Indians that sided in favor of the Cherokee. And Andrew Jackson, who would go on to sort of oversee the Trail of Tears, is said to have replied, well, John Marshall has made his decision, now let him enforce it. In other words, Jackson, as the president, thought, I don't like this decision of the court, I'm not going to enforce it. Abraham Lincoln did the same thing. There were decisions of the Supreme Court that Lincoln disagreed with. The Dred Scott decision is one, and there were others involving civil liberties in wartime, and Lincoln simply didn't enforce the decisions of the Supreme Court. And so, again, Brutus sees the courts as being all powerful. Hamilton says they're actually very weak. And one other thing I want you to notice in this paragraph is that Hamilton says it may be said to have neither force nor will, but merely judgment. And you can think about a posture thing here. If someone has force and if someone has will, they're able to exercise their own authority. If you have force and will, you're going out and looking for problems to solve. You're active. If you are exercising merely judgment, you can think about that as a posture of sitting back, as a judge is sitting back, waiting for cases to come before them and making measured decisions based on the Constitution. They're not exercising their own will in their decision-making. Now, he goes on, next paragraph, bottom of page 228, this simple matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. Now, I think when Americans today would see language like this, we would find it kind of jarring to think about the branches of government attacking each other. But this is exactly the system that the Federalists set up, where they envisioned that you were going to have clashes between the branches of the government. And that because there's these clashes in the system of checks and balances, the branches need to be able to defend themselves or be protected against some of the attacks of the other branches. And so for Hamilton, one of the reasons that you give the federal judges life tenure, you insulate them from politics, and you make it so that they can't just be gotten rid of, or you can't diminish their pay, is so that the court will not become subservient to the legislative branch or to the judiciary. Now, so Hamilton has now responded to Brutus in terms of the strength or the weakness of the federal courts. He then goes on to answer Brutus on the question of judicial review. Again, Brutus roots the idea of judicial review in the word equity. Hamilton finds it in a completely different way. And if you look at the middle of 229, he says this: the complete independence of the courts of justice is peculiarly essential in a limited constitution. And now he's going to define this concept. By a limited constitution, I understand one which contains certain specified exceptions to legislative authority. And then he says some things that Congress can't do. So a couple days ago in class, we looked at Article 1, Section 8. And that lays out the powers of Congress. So Congress is expressly delegated certain things that it can do. And the question is, what happens if Congress or the president exceed the limitations that are placed on them by the Constitution? What happens if they do something that they're not supposed to do? For Hamilton, this is the basis of judicial review. Again, back to the middle of page 229. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. So if Congress or if the president exceed the authority delegated to them by the Constitution, someone has to step in and say, no, you can't do that. And for Hamilton, it's the federal courts. They are the branch of government that has the power to step in and say no. He goes on the bottom of 229. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. And then in the middle of 230, right in the middle of the page, he says that it's the role of the courts to keep the latter, Congress, within the limits assigned to their authority. The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. So the courts are responsible to interpret the Constitution and to interpret the laws of Congress. And the question then is, what happens if they conflict? He says in the next sentence, what happens if there's an irreconcilable variance between the two? So what happens if the Constitution says one thing and Congress or the president says something else? And he says, obviously, the Constitution must prevail because the Constitution is the supreme law of the land. And he goes on to say, you must prefer, if there's a conflict between an ordinary law passed by Congress and the Constitution itself, he says the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. And this is really important. For Brutus, judicial review is undemocratic because you've got these unelected elitist judges who are making decisions and there's no way for us to hold them accountable. We can't fire them. We can't vote them out. And as we talked about in class, the only way to overturn what you might consider a bad decision of the court is to either fight for generations and try to get the decision overturned or try to amend the Constitution, which is really hard. For Hamilton, judicial review is actually quite democratic. Because for Hamilton, judges are upholding the written Constitution, the Constitution that begins, we the people. It's our fundamental will. And he says here, it represents the intention of the people. So for Hamilton, judicial review works. Congress passes a law. Constitution says something. The law conflicts with the Constitution. And one of them has to win out. And for Hamilton, the Constitution should always be superior, and the Constitution represents our supreme, highest, most fundamental will. And therefore, judges are doing something inherently democratic by upholding our will. Now, he does throw a little bit of a bone to Brutus on the bottom of 231, just a little more than halfway through the page. He says, it can be of no weight to say that the courts on the pretense of a repugnancy may substitute their own pleasure to the constitutional intentions of the legislature. In other words, courts ought not to strike down laws and do it based on their own personal views, but pretend that it's being based on the text of the Constitution. He says, I'll skip a sentence. He says, the courts must declare the sense of the law. And if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. The observation, if it proved anything, would prove that there ought to be no judges distinct from that body. And so what he's saying is essentially, I think Brutus is wrong. Judges are not going to do what he thinks they're going to do. But if they did, then he's right in principle. Judges ought not to have life tenure. They ought not to have salaries that are protected by the Constitution so that they can never be diminished. Judges ought to be elected by the people. If judges are going to act like politicians, then yes, they should be treated like politicians. They should have limited tenure of office. They should be accountable to the people. But Hamilton doesn't think that's what's going to happen. He thinks judges will be bound by the text of the Constitution, and that judicial review will be rooted in the text of the Constitution. Now, Hamilton goes on then to talk about the type of people who will become judges. In his case, of course, it would be men only. So when he talks about it, he talks about the type of men that he would expect to become judges. And this is also a really important point to get out of Hamilton's argument. So Brutus is worried that only the elites will become judges and that they won't really reflect the people and that they will use their power and office to increase their own power and their own wealth. And ultimately, he talks about to destroy the states. Hamilton responds by saying, actually, you want the elites to be judges, because you want people who are going to have fortitude to be able to stand up against the political winds. You know, presidents can put a lot of pressure on judges. Congress people can put a lot of pressure on judges. So you want people who are going to be able to stand up against that. And then the other thing is, there are a lot of cases that arise and a lot of precedents, and judges need to know a lot of stuff. And so if you look at the top of page 234, he says this: it will readily be conceived from the variety of the variety of controversies which grow out of the folly and wickedness of mankind, that the records of those precedents must unavoidably swell to a very inconsiderable bulk, and must demand a long and laborious study to acquire a competent knowledge of them. We talked a little bit about this in the last class. There are thousands of courts and tens of thousands of cases going on at any given time. And that's because people are fallible. People hurt each other. People take advantage of one another. People do bad things all the time, and it leads to cases. And so there are tens of thousands of cases going on in this country at any given time. And hundreds of those cases rise to higher levels and then become really important precedents. And Hamilton is saying, look, you don't want ordinary people being judges. You know, maybe farmers have common sense, but you don't want farmers to be judges. You need people who are going to know the intricacies of the law, who are going to be able to keep track of all the precedents, who are going to be able to make those decisions based on the law. And so, in essence, you need the elites to be the judges. And for Hamilton, that's a good thing. In the same way that Madison makes a similar argument in Federalist number 10, where he says that in a large republic, you're more likely to elect better people who are going to have a better sense of what's good for society than even if the people themselves were making decisions. So you can see how Hamilton is responding to Brutus on all these different points. He's responding to Brutus on the power of the courts. He's responding to Brutus on the way judicial review will work. And he's responding to Brutus on the elite nature of who the judges are. Now, I want to just close by bringing things together, and hopefully, maybe I should have covered this at the beginning, but hopefully this will helpfully bring things together and help it make sense. When we talked about the grievances in the Declaration of Independence, we talked about how things like the Administration of Justice Act of 1774 led to the grievances. So they were moving trials over to London, and into the grievances, they write about judiciary powers. So Jefferson writes about how judges are dependent upon the king. They can lose their jobs. They can lose their salaries. Jefferson writes about how the administration of justice is not protecting people's rights, and the trials are being moved far away. And so the founders, when they wrote the Constitution, they answered those grievances. And in Article 3 of the Constitution, and then ultimately in the Bill of Rights, you have judges have life tenure. You have judges whose pay can never be diminished. And you have the rights of criminals protected, so that you have a right to a jury trial in the state or district where you're accused of having committed a crime. So when they wrote the Constitution, the Federalists saw it as, we are upholding the principles of the American Revolution. We are putting protections into our Constitution for the rights of individuals who are accused of a crime and also protections for federal judges. We're giving them independence from the president and from Congress. The Federalists saw their creation of the courts as an upholding of the principles of the Revolution. Brutus saw things entirely differently. From Brutus's perspective, this power being given to the federal courts and this independence being given to the judges was going to allow them to abuse their power and therefore undermine the principles of the Revolution. So when we read Brutus on representation and we read Brutus on the power of the courts, in his mind, the Revolution was fought to protect liberty for individuals from a powerful, distant government. And Brutus believes that the way Congress and the courts are going to be constituted is going to lead to the destruction of liberty and lead to a tyrannical government. And so, in a sense, both sides believe that they are upholding the principles of the Revolution, but they have very differing views of what that looks like. So I hope that this helps make Federalist 78 make sense. I hope that you can see the debate between these two sides. And I'll just say one or two other things about this. I mentioned in class last time, most of you have probably been taught that judicial review was established in the Constitution. Was established in Marbury versus Madison in 1803. What I hope you see now is that if you were taught that, which I imagine most of you were actually taught something that was wrong. Here you see, before the ratification of the Constitution, these two founders are debating judicial review. They both recognize that it's present in the Constitution before the Supreme Court is even created. The second thing is, and I won't ask you about this on the exam, but I talk a lot about this in my American Studies 120 class, is that the debate that these two judges these two politicians were having in 1787 and 1788 is actually a precursor to debates we have today. Do you stick to the text of the Constitution only? And does its meaning remain static? Or do we have a living Constitution? Maybe you look outside of the words of the text of the Constitution. That debate that we have today between what we call originalism or textualism and living constitutionalism is actually an outgrowth of the debate that Brutus and Hamilton were having. So their debate over 200 years ago, almost 250 years ago, is really quite relevant to the debates we have today every time a judge is appointed to the Supreme Court and the senators ask them about their judicial interpretation. They're going to articulate a view, and almost certainly their view will be somehow rooted in one of the views that was laid out by either Brutus or Hamilton. So I hope this makes sense. I hope that you can use this video to make sense of the reading and to get ready for the midterm. And I will see you all in the next class.